Welcome everyone, and thank you for joining us for our final panel of the day and at our first Commercial Receivers Association conference. As you heard this morning, we've got some exciting news that next year we'll be live in person in St. Louis, Missouri. And hopefully you've taken a look at some of the call for proposals if you're looking to speak at next year's conference, as well as some of the other materials on our website. But we're really excited to close out today with a great panel discussion. We've got some great speakers here. Brent King is the State Director of Missouri, and he is at B. Riley Financial. We've got Ryan Gulick, who is our State Director of Colorado and is at the Receiver Group, and Marc Spector is our State Director of Texas and has a firm down in Dallas, Spector Cox. We've also today had the great pleasure of hearing from speakers from across the country, engaging us on the future of CRA, on legislative change, banking perspectives, and insurance and bond issues. So really some good topics that really can apply to everyone. They're not just necessarily tagging one group with information. I think that all of those issues apply to us no matter what role we play in receiverships. And that's why we felt today, closing out the day, it was great to hear from our state directors about some of their experiences going on today and what's happening in their states. And I was thinking about this because I'm a numbers person and this is how my brain works. The respective communities that you represent in the CRA represent probably close to 75% of our membership today. And it makes sense. You're the 3 states we've launched in, so we would hope you would make up the majority. It would look odd if it didn't, but you're representing a significant demographic of our membership here. And as we continue to grow the CRA, the state directors really play a critical component that we're just on the cusp of really rolling into with you all. You guys are the main point of contact for those members and really starting to create a voice for the CRA, connecting legislation, events, education, and networking. You become the voice of the receivership community in your state, which is obviously critically important when receivership laws are state-based. And so you, in some ways, I mean, maybe I can say it and maybe I can't, and either way, there's only 4 other people watching us currently, so I can say it and no one will hear, but you guys are the most important people in your state in receivership. So with that said, let's introduce you to the most important people in your state in receivership. So as I mentioned, Brent King is the State Director of Missouri. Brent is an executive management and financial advisory professional with over 22 years experience in distressed management and advisory services and over 32 years experience as a corporate executive leader. Prior to joining Glass Ratner, now doing business as B. Riley Advisory Services, Brent served as the founder of Prairie Advisors, a middle market corporate advisory firm that placed Brent into multiple interim management and advisory roles at heavily distressed corporations. Brent has served as the C-level executive or senior advisor to both public and private corporations. Brent has extensive experience leading distressed businesses, operating complex startups, and advising insolvent businesses. His roles include CRO of public and private corporations in Chapter 11 bankruptcy, Chapter 11 trustee, judicial receiver, advisor for corporations for pre-bankruptcy planning, forensic investigator of financial fraud, director of patent infringement defense, valuation advisor to buyers and sellers of corporate assets, and liquidator of manufacturing assets and facilities. Mr. King has worked with corporations in a broad range of industry sectors, including food and protein processing, production agriculture, biodiesel and ethanol production, metal manufacturing, plastic injection molding, automobile dealers, agriculture equipment dealers, livestock equipment distributors, and livestock and dairy production. The certified turnaround professional and a member of the TMA and ABI, and earned a BFA from Western Illinois University and an MFA from Northwestern University. He's also the named inventor of several US and foreign patents, an industry-rated pilot, a musician, an experienced woodworker, and a graduate of the Leadership Trust. And I might also add, I cut stuff out of his profile to get down to just saying that much. So he's obviously led quite a unique background and really experienced in this field of insolvency. And so we're really privileged to have him as our State Director of Missouri. Marc Spector is the State Director of Texas. Howard has practiced bankruptcy law since 1992, first with the law firm of Scheinfeld, Maley, and Kay, and then with Hughes Luce before establishing his own firm over 2 decades ago. He has served as counsel to large multinational corporations, as well as to smaller firms and individuals on both the debtor and creditor side of the table. Currently, his practice focuses on middle market and small business clients seeking advice on how to restructure liabilities in a challenging business environment. Howard also maintains an active consumer bankruptcy practice, advising individuals facing financial hardship and assisting creditors in consumer cases as well. By not limiting his practice to one side of the debtor-creditor equation, Howard believes that his experience as both a debtor and creditor's lawyer allow him to provide tailored advice to his clients no matter where their interests lie. Mr. Spector also serves as receiver for courts around the state of Texas, assisting in the rehabilitation, stabilization, or orderly liquidation of business enterprises. I think that's actually a really well said way to word that. So someone at your firm, Howard, is a strong wordsmith. In past years, he has served as a receiver for trucking concerns, energy companies, manufacturers, heavy equipment resellers, multifamily housing owners, as well as individuals under court supervision. Ryan Gulick is the state director of Colorado. Ryan founded the Receiver Group and is an experienced court receiver for all types of matters. For the last 16 years, he has served in various receivership estates and appointments spanning various types of disputes and resolutions. Ryan started as a receiver in distressed real estate and asset protection in 2006. Recognizing the upcoming economic downturn and wave of residential and commercial loan foreclosures due to the recession, Ryan endeavored to build a professional receivership firm. For the next 7 years, Ryan successfully established himself as one of the top skilled and appointed receivers in Colorado. In late 2015, Ryan founded the Receiver Group to expand on his vision and drive to be the most trusted and equitable solution when receivership is needed. His vision and drive, he specializes in many types of appointments ranging from post-judgment collections, equity disputes, real estate protection and management, and cannabis industry specific matters. Ryan is also a real estate professional, knowledgeable in both residential and commercial industries. His overall guiding philosophy is trusted, equitable solutions, where in every case, fairness and his approach to protect, manage, and resolve are the keys to the receivership group's success. Got through all of that with only a few stutters, so I'm very proud of that. What you can really see out of that is we have 3 really esteemed, privileged, great leaders of our states that we've appointed so far, and we're really happy that you 3 are a part of this group. And so I'm going to just kick it off with, the question of the hour. Brent, start with you. How are receiverships being utilized in the state of Missouri? What are you seeing that's really of value here?
Well, I certainly think that the receiverships are going to be used much more substantially in Missouri going forward. They're growing all the time. Missouri has a fantastic receivership statute. The most significant issue that I have actually encountered as far as use of the receivership is probably agriculture. And right now I'm working on a receivership that is involved in the timber industry, but hospitals, agriculture, timber, pretty wide spectrum of receiver uses.
Ryan, how about you? What are you seeing as the most common uses of receivership in the state of Colorado?
Yeah, again, this is my perspective, but I think the cannabis industry is of primary interest right now in the receivership community, simply because the market and the price of flower has declined so much. It's causing distress in the cash positions of these companies, and therefore you see partnership disputes. And they don't have federal protections in bankruptcy courts, so receivership's the obvious choice for those guys. And then certainly I think the commercial receivership side of things for creditors' rights and the protection of assets and defaults and contracts, where the provisions in the contract or the loan documents provide for the relief of a receiver, are coming into play more and more now that this economy is sort of slowing down. There's downward pressure with the interest rates, and which causes some distress with these companies when they need to refinance. And certainly still in the private sector, though, we're not seeing the flood of of business with commercial banks. I think they cleared up their balance sheets pretty well back in 9, 10, and 11, but I think that will become more prevalent here in the next couple of years. We'll just have to see what the global economic factors are. So, and then really just sort of the post-COVID sort of factors that affect all businesses when you talk about equity receiverships, when you're just dealing with partnership disputes or marital dissolutions that are coming out of either business partnerships or situations where, you know, there are companies or assets that need to be dissolved where there's people fighting over it. That a lot of divorces came out of COVID as well, unfortunately.
Howard, how's Texas looking right now? Obviously, Texas is known for its bankruptcy. How about on the receivership side?
On the receivership side, we're usually dealing with uncontested assets in an uncontested case where management has no interest in liquidating the collateral, or there's tremendous liability attendant to that, or in cases where there's a director and officer suit by the secured creditor. I don't see receiverships that often in cases where the debtor, borrower, and secured creditor are at odds, because generally the debtors run to bankruptcy court to avoid a receivership. And then, of course, as Ryan said, divorce cases that have substantial assets.
So, you know, there's a lot of directions we could go out of what the three of you just shared there. I'm actually looking at my next three questions, and I think Brent led into the first one, and Ryan led into the second, and Howard led into the third. So clearly, all three of you are well versed in what we thought we would talk about in this panel. Let's take a moment to talk about some of the receivership practice, and whether it's in growth mode. And Brent, this is where I think you really touched on this, where that statute change has really started to show some growth, but it obviously has the potential. Clearly, we all see something going on in the interest rates and the liquidity of banks and all of these lenders is likely going to change things. Do you all see a lot of growth happening in your states coming up? Howard, you're on the big screen. I'm going to toss it to you first.
I'm sorry, you cut out.
Nope. I was simply saying, do you see receiverships expanding or contracting in the coming months, coming years in Texas?
We're actually starting the process of making our very, very antiquated receivership statutes at least into the 20th century, maybe not the 21st century yet. But most of our receivership laws were written literally in the 1800s. So I would say it really only has one direction to go, because right now the statute's very ill-defined. Judges really don't know when receiverships are appropriate or not. So I would say, yes, I would expect to see more, even if it's not in the next year.
Yeah, and for Colorado, I'd agree. I think we're on the uptick, although we've been sort of expecting a stronger wave of receiverships over the last several years, and it just hadn't happened. I mean, I think I speak for a lot of receivers in Colorado that a lot of us had some of the busiest years that we've had during COVID, despite it all. But it certainly hasn't slowed down. As we've talked before, Eric, it's interesting to see if you consider a lead coming into your office for somebody that wants to get a receiver appointed, out of 10 receivership situations, how many really truly come to form, knowing that there's, so much runway sometimes to get a receiver appointed, depending on the litigation that's going on underlying. But those numbers are still relatively low, as we talked about. Out of 10 maybe potential leads, you might have 3 or 4 that come to fruition, and the timeline of those coming to fruition could be months. Sometimes it's years. I still have pending cases that are still going on, and we're a year under waiting. But Definitely think in the commercial side of things with lending and property, given the fact that commercial space is vacant and situations are going on. Restaurants, I think, are another area that are still struggling. And so we're seeing an uptick. That cannabis is another one. With regards to the legislation, we're firmly rooted in Rule 66 here for the equity side of things, other than the contractual obligations that are allowing receiverships to happen, even ex parte. I think for us, it's just finding consistency with the judiciary so that the judges are feeling like there's appropriateness assigned to a case on their side, an education from their side, knowing that they feel comfortable with a receiver being appointed. I was in court today with a judge that asked for a 30-day hearing because he just wasn't certain about the receivership. He appointed the order, but he said, I just kind of want everyone to get together in 30 days so I can feel comfortable that I didn't make a mistake here. And of course, we proved that today, but I feel like, as us receivers know, our reporting to the court's the best way to educate the judges on how good a receivership is and how it's important and the effects it can have, and how we can keep people out of their courtroom and, help the resolution, maybe be expedited. So definitely see Colorado as a place as receiverships continuing to grow. We're sort of a hotbed for people to want to live and bring their businesses. So with that growth, we certainly see a lot of money coming into the state, but we also still have the same amount of problems. But that being said, the supply and demand, we don't have a lot of receivers compared to some other states. I mean, you look at California and we're a speck of sand, but we still have a significant amount of professional receivers that are, I think, doing active business and staying busy. So I like to see that.
Brent?
Yeah, Missouri is definitely up. The statute is broad, it's powerful, and it will facilitate a real expansion in receiverships. I actually started practicing here in 2017 when I joined Glass-Ratner. That was about the time that the statute was implemented, 17 or 18. So I don't have a lot of pre-Missouri commercial receivership experience, but it's very powerful, and it really is a great option to work out alone.
And I think it's a good point, and Ryan, you kind of touched on it as well. You educate the judges by going into court and letting them experience everything that you have to provide of why you're doing something, and that judge can slowly learn. Now, obviously, they have 19 other cases on the docket that day, and that makes it difficult for them maybe always to remember what they've been taught, but it really is an interesting perspective to it all. I know, Brent, we've talked about this Missouri legislation, which passed in 16 and probably really went into force in 17, is not that it in 2017, all of a sudden it was an aha moment for the courts that this is a great opportunity. That's something that has to build, and as the judges get a little more used to it and a little more comfortable to do it because they see it in a place like St. Louis or Kansas City, there is that opportunity to really utilize it better. That's maybe seen less frequently in rural communities, and those judges maybe don't have that same experience. Colorado, Texas, Howard, you talked about legislation change really being something that could lead to it. Ryan, how do you feel about the legislation in Colorado?
I don't have a lot to say about it, although I don't feel like there has been a lot of issues getting receivers appointed utilizing the statutes as they are right now. However, it's not to say that some uniform code might not be beneficial so that there's consistency. I think, again, if we've got several levels. The judges don't know anything about the receivers being nominated in front of them, so they're relying on the attorneys to vet and propose whoever they are. And if no one's fighting about who the nominated receiver is, then the judge generally has that discretionary right that they always reserve. But as long as the statute provides for it and the circumstances are providing for it, they're generally open to it. Where I feel like Colorado definitely could benefit is just, maybe some consistency in the operations of how the dynamics of receivership works through the court system, so that these judges are more comfortable appointing a receiver, knowing that these receivers are they're educated. We come from all sorts of different backgrounds. They're either attorneys by background, or there are a lot of ex-judges that do arbitration work and mediation work that also do receivership work, and they come with a lot of background that people are comfortable with. But most of us have a professional background in some area or resource that makes us adept. Either it's business, finance, and law. And, that's all good and fine, but ultimately the judge needs to know that there's just not going to be a mess made of everything. And I think it boils down to really good attorney work for those attorneys that are looking to appoint receivers. And I think it starts there with, proper motions being put in front of these judges, quite honestly. So I find that I get appointed most often when there's good counsel representing the parties that are moving to put a receiver in place. But again, you need to have the judges feel comfortable with it so that, it's still viewed as, the most exigent circumstance and the last option. For most litigating attorneys and most judges are still viewing receivership as the last option, just because of the expense involved with it and what it means for the parties that are being put into receivership. So, could we benefit from some uniform code? I think it'd probably be good for us. But again, I think you need to allow for, and I wasn't part of the whole panel earlier where you guys were discussing this, but every receivership's different, and that's why we all like these broad scoping orders that give us all the authority we need to navigate any situation that comes up, whether it be a bankruptcy filing or claims for creditors and setting bar dates for dealing with different claims and stuff. But I just think as long as we allow room for adjustment, I think that would be the key thing for me. I come at it from a pure operator standpoint, needing the flexibility to do what we need to do.
And so you touched on it a little bit earlier too. Talk about the depth of the receivership community in your states. So Brent, you and I both operate in Missouri, although I know you operate nationwide. But within Missouri, do you feel that there's a strong depth of receivers, attorneys, support professionals that both understand the practice and how to work within it? Because you can't just go to any accountant, right, and say, hey, I need this done for a receivership. And, half of them, one of the people that works for me always goes, what Britney Spears was in? It's like that, but not for personal. And I'm like, well, that's not really how we want to help define it. But, how do you feel about the depth of the receivership community in Missouri?
Well, I think it really that question really sort of opens the door to a conversation about what the CRA can actually do to help improve the effectiveness of the receivership that happened in Missouri and other states. So, as I look at this, there are basically there are really, first of all, we assume that we have receivers that we're dealing with receivers who have a highly skilled, competent understanding. So the CRA can definitely help build that through educational processes. But there's also 3 other groups here, well, at least 2. So we've got judges, and we've got banks, and in some cases attorneys who may not necessarily understand all they need to understand about the receivership process in the state they work. So I see a huge opportunity to help. Missouri is just full of small regional and local banks. All of them at some point are going to have a loan that needs to have a process, some sort of workout. And I'm actually working in an interesting receivership right now, which brought in all of the above. The whole spectrum of people were probably less skilled at developing the receivership or working in it than they should. I'm working under an order that was less than optimal. I was working originally under a judge who had entered the bench the week before. An initial judge appointed me, retired the week later, and handed the order to a brand new judge in what is really a very highly complex receivership. And through an appointment in a bank who had never done a complex workout as well. So where's the opportunity? Well, it's getting in front of banks, helping them understand how to use the receivership and how to prepare for it and when to. Getting in front of attorneys who'd like to represent banks or receivers and help them understand how to better utilize the laws. And I guess finally, perhaps helping the judges in at least in Missouri and the other states that have strong receivership codes, understand insolvency and understand how to use the law to work through these cases.
Ryan, how about you? You want to talk about the depth of receivership? Yeah, you touched on it a little already. And basically, I mean, obviously, Colorado in the last 20 years has exploded. I've actually lived there twice during those last 20 years, so I've seen the before and after effects a little bit of it, but you know, the professional community maybe hasn't caught up, is what I think you were saying.
Well, you know, I think we have a good group of very professional receivers that do this work and only do this work. And they may have some ancillary business that they're involved with as auditors or CPAs. And you've got firms that provide all sorts of other services that are ancillary to receivership work as well. But we're seeing firms from California open up offices in Colorado, which is good and bad. You know, I think that what you know, to touch on what Brent's saying, I think, you know, what'll be interesting for this state director role and for the CRA is to see how open receivers are going to be to collaborating about their business and about, you know, the work that they're doing. You know, so far, you know, we're sort of lone rangers out there, and we have our clients, we have our attorneys, and the people that we like to do business with and that we have as our pipeline, and, you know, and we don't want to lose that. And so we've traditionally been, you know, not reclusive, but very guarded with being out there with what the secret recipes are and how we do work. But those that are doing good work and are out there doing a lot of work are known to most of us, because generally when we get phone calls for a nomination, they're in the mix. And then we've just got I think we've got a good representation of the different levels of receivers as well in terms of what they're handling. You know, we've had a lot of, you know, kind of multi-level Ponzi scheme, financial, very big cases that, you know, there are only a certain number of receivers in Colorado are adept at handling and handling well. And then the attorneys that come along with that and the teams that are put in place to sort of manage through those complicated cases. But, you know, there's a whole handful of one-off receivers and the people that do all the bank work and get one-off appointments to protect receiverships and so on and so forth. I'm really, you know, I don't have a great answer for you. I think Colorado, as far as the rest of the country is concerned, I think we don't have a ton of receivers here, but the ones we have are really good, and they're focused on doing the work. There's always a few bad apples out there, and but they don't end up lasting very long. Those of us that have been in the business longer than 10 or 15 years, I think, are the ones that will be around and continue to do the good work and help develop this business. And will it be as huge as California? I don't know that Colorado will ever get there. You know, in the states where bankruptcy is just, you know, all litigation is just, you know, astronomically high. But I think as our economy grows in Colorado, I think the receivership business will follow it. You know, we're opportunistic people. We follow the ebbs and flows of the economy, and, you know, if it's oil and gas, if it's marijuana, that's where the business is going to be sort of fluctuating and the pendulum is going to be swinging around. But every time that happens, those of us that are active and doing good work, we're building that repertoire in that sector. So for me, over the last 18 years, I've been able to just develop those sectors of business as each economical situation happens, you know, oil and gas, marijuana, real estate. And so that's sort of how I've built my business. And that's kind of the school of hard knocks, really, for me.
Yeah, I mean, obviously the CRA we take an approach of, you know, a rising tide raises all ships, right? That the better we can network and educate people who the right people are, because you touched on it, there's the one-offs that probably got appointed to something they shouldn't have been, or maybe they end up doing a really nice job with it too. But you do have the horror stories are usually the one-offs that shouldn't have really been appointed in the first place. But, you know, they were an attorney's friend, a judge's friend, a banker's friend, whoever it might be. But, you know, we see an opportunity, obviously, to really build a stronger community with networked and educated people. You know, I think what you didn't touch on there as much of was the attorneys. And one of the things I heard while we were out for the launch event was the attorneys in insolvency work in Colorado ebb and flow based on the work. And so right now it seems like it's a downtime for the amount of bankruptcy and receivership attorneys in the state of Colorado. But obviously, to your point, if that tidal wave ever hits, maybe they'll all come flowing back in.
Yep, I would agree with that as well.
Yeah, and we see it a little bit of it here too in Missouri as well. Howard, how about you?
I would say our group is very segmented. We have folks who specialize only in collection receiverships. I don't do any of those, for example. We have folks who, as you mentioned, are simply appointed because they know someone, and those are usually the cases that make the papers, either because the fees are completely out of control or something terrible has happened. A few years ago, there was a receiver who was running a trucking company and forgot to get liability insurance. And of course, one of the trucks hit someone. And not only does the receiver obviously have tremendous exposure, but everyone's looking at the judge saying, why did you pick him? He doesn't have any background in the trucking business or any knowledge of the industry, and no one really has a good answer. So I would say in most of my cases, I have a financial advisor with some level of experience in the industry. Oftentimes now it's healthcare or some sort of consumer collection receivership, like a credit card receivables company. But in that case, I would have someone who was familiar with all the FDCPA rules and the state-by-state requirements for debt collection. So I think, in addition to getting good people appointed, I think you have to have good people around you so that you're not stepping in any holes that you don't know about.
I think that's a really good point, and we didn't touch on it as much in the other two states, but I noticed it while we were in Texas for the launch event that there was a very full and deep community on the support side. And we heard from the banking panel today, they don't hire the receiver alone, they hire the team. They look at who the attorney for the receiver is. They look at who they're going to use for forensic accounting, whatever other pieces there are to that puzzle. They want to make sure that the whole team is ready to play and that it's not just a one-man show or a one-woman show. And so I think that was something that I came away with when we did the Texas launch event, was there was a depth and a breadth that I assume comes from the bankruptcy side, that there's been that deep experience of bankruptcy in Texas, and therefore that support community has kind of evolved out of it, that maybe isn't as deep and strong in some of the other states across the country. I don't know, do you have anything to add to that? That was my own personal takeaway from when we were there together.
No, I think you're absolutely right. I mean, oftentimes my financial advisor earns far more out of a receivership than I do, because they are doing everything day to day on the operations side, managing employees, reconciling accounts, and I'm there to direct and for hard questions and maybe to implement some strategy. But they're the ones billing 8 hours a day, or on 5 people.
Yeah, I think one of the things that we've touched on a little bit between the three of you, and is a nice evolution out of the receivers, the attorneys, and the support professionals, is the judges. What's your experience been like with judges in your states, and where do you see an opportunity with the judges?
I would say, our judges know very little about receiverships. They don't see them very often. They haven't thought about them very much, and except on the collection side, there's really not a pool of people who do this kind of work aside from 4 or 5 of us, at least here up in the northern part of the state. And I think the same is true down in Houston. There's very few. If I see a receiver in a commercial business, it's almost always one of 3 or 4 people. But I think educating the judges is the hardest part of the job. The lawyers are comfortable with it.
And you do have a unique statute in that you have to be a registered voter in the state of Texas to be a receiver. So those of us that are on the outside looking in have to find a good partner to dance with. So, that's always, every state again is unique. But Ryan and Brent, how about you? Experience with judges?
Yeah,
Tim?
sure. I'll start. This is Brent. Well, they run the gamut. I've been a receiver in front of judges that were extremely effective. For some reason, I seem to get a lot of cases where the debtors are highly resistant to the receivership, either the appointment or to complying with the law. And they seem to make a lot of waves. And I've had courts that were absolutely intolerant of the debtor's refusal to turn over documents. And I have other receiverships where I am still waiting for the initial documents a year later. So it makes these cases very difficult. One of the things I think I would really like to do to help the judges, and I'm sure everyone has talked about this before, but the importance of writing fantastic appointment orders. And in those orders, the expectations about when documents should be turned over, when information should be turned over, should all be included. These are highly important things. But to end up in the 12th or 13th or 14th month of a receivership and not even know how the assets were insured is, for example, is an absurdity.
I do think those documents that you talked about, that is a part of kind of the future CRA plans, I know is more standardization of documents. And while it maybe isn't nationwide standardization, there could be statewide standardization of documents that hopefully remove some of the intricacies that one lawyer writes into an order versus another, and hopefully starts to at least create a path forward to a common document that we're all utilizing, and hopefully strengthening, and hopefully the CRA can play a good role in that. And I think obviously that's a great resource as a member to be able to just download documents that are template documents that could be utilized. So I like that your head's headed in the same direction as ours there.
Well, let's just think about that for 1 second. Let's assume we have really high profile states with really high quality receivership statutes, and there are many of those things have consistent provisions. So in each state, a high level document could be tweaked. But in states that don't have really sophisticated receivership laws, many times the judge will approve sophisticated orders that may have been based on the concepts of other states' law. So, for example, I did a receivership in Colorado a couple of years ago, and I asked the attorney that represented me, what can we get in the order? And they basically said, whatever you can get the judge to agree to. So there you go. Let's start with a great order and see what we can get.
Ryan, I kind of jumped you there on the judge's commentary.
Yeah. No, I mean, I agree that with Brent. I mean, I don't see that I've never had, it's very rare that I've had a judge nitpick provisions of our order specifically. It's generally more broad in terms of whether the appointment is necessary or should be something that they should consider. The order is really rarely ever something that I've seen a judge focus on, other than maybe the reporting requirements. And service requirements and things of that sort, that they want maybe an extra level that the receiver needs to be involved with. But, to a question Eric Peterson's asking, and I think what we've all touched on, I think the value of the CRA moving forward really can be, I mean, look, is educating these judges. Like, let's receiverships are a very unique situation, and they're not every day, right? Your phone doesn't ring every day like you're selling a widget. It's a situation that has to come up. It usually goes through several weeks, if not months, of lawyering before determinations are even considered for a receivership. And so there's a lot of work that goes into these. And, to get through that whole process, just to have a judge deny an order for receiver is the biggest letdown, I think, for everyone involved, other than the people that might be losing their assets to a receiver. But to me, that's the most important point in all this, because it's what we don't have control over at the very end, after all of us do the work, putting ourselves out there, presenting our CVs, getting the rates negotiated, the lawyers putting the motions together, having their complaints and the pleadings. it all boils down to whether a judge is comfortable with it. And if you're in front of a judge, which is always a roll of the dice in most cases, sometimes they know who they're in front of already, but it's the key thing to that metric we were talking about earlier, Eric, is out of 10 receiverships, if we can get 5 out of those 10 instead of 3 out of those 10, then I think we're all doing a really good job. Ultimately getting the receiverships that, want to be presented to a judge approved should be our goal. I think the lawyering, as we've talked about, is on par. It's great. These lawyers know what they're doing. Their motions are right. And it's just really more global factors like the parties objecting to the reasons of the receiver being appointed that the judge is being more discretionary about, is what I'm seeing.
Yeah. So we've talked about kind of how receiverships are utilized in your states. We've talked about the players in the states. And this is where I kind of wanted to spend the last 15 to 20 minutes to talk about what can CRA do for you. And maybe that sounds a little bit like a PBS special, but what would you like to see out of the CRA in your state? Growth of membership, programming, whatever it might be. Why did you guys sign up to lead the way in your own states? What did you see as an opportunity there? And Brent, I know yours was just we were out drinking and and you signed up. We took your yes and ran with it.
Well, the real objective of all professional organizations is to enhance the profession around which we are organized. And there are so many opportunities for improvement in process, and they all center around education and information. And so from my perspective, what really seems to be the most important thing that the CRA can do is to help educate everyone who is involved in a receivership and to provide better documents and information sources. We've done some really interesting things in receiverships here in the last couple of years. We've had some important rulings. We've seen really important growth in the understanding of receiverships. Hey, one group of people we should probably talk about is the title companies. They seem to kind of control the outcomes of most of our cases. I think I've heard everyone believes the judge has the ultimate decision in how an asset is liquidated. But actually, it's the title companies. So we need to integrate them into a deeper understanding of our state laws.
Really great point, because we've heard that not just in Missouri, we've heard that in Texas for sure. That's a common thread amongst all the receivership profession. So really a nice point, and probably one that we want to and need to take a bigger look at. Ryan, how about you? What do you see what would you like to see out of the CRA in your state?
To echo a lot what Brent was saying, I just think the collaborative energy that could come from learning from the other professionals in the state, as long as we're all open to being a little vulnerable and not worried about losing business or, the competitive side will always be there. But I think we have a lot to learn from each other in the different business sectors that we work in. But I think the CRA as a database can start, really just build a lot of credible resources for receivers in all the different respects of, what we touch when we get appointed, from the pleadings and the proposed order, affidavits, different settlement agreements, stipulations, requests for instructions, and all the different things that we go through when we get into a receivership, and then maybe base those on the different types of receiverships, whether they're business partner disputes, which, I think, we're focusing on marijuana. We got a restaurant receivership kind of panel coming up. So we're touching on the different kinds of receiverships, and all those come with a different set of needs that we all have to, and it's just a process, right? It's a puzzle and it's a chessboard, and it's which piece you're moving first. But the CRA, I think, could sort of wrap its arms around all the different aspects of what the toolbox is a receiver might utilize. So I think that's one primary resource. And then obviously, as I echo what Brent said, the education of it all, for us to be, participating in best practices And I think that would permeate also to the judiciary, whether they're involved or not. We may get ex-judges that we could get input from, but the active judges, I'm not certain about it, but I think it will permeate to them to know that if there is this organization and we build momentum with this education and consistency, whether it's an act or just a uniform code that we're all just agreeing to abide by in our states, it will build credibility for when that judge is looking at certain receivers. And if they're questioning, appointing a receiver, if they know they have a credible receiver looking to be nominated, at least the judge knows that they'll have some control over the situation getting crazy, right? As opposed to just being like, well, let's throw caution to the wind and see what happens here. So, I'm just looking forward to really, kind of getting to know the receivership community in Colorado a little bit better, and just seeing if we can make a collaborative effort to really, build the business in Colorado. We'll see if it can happen.
And Brent touched on it a little bit earlier for Missouri, but having lived in actually all three of your states, I can say fairly confidently, similar to Missouri, there are a lot of small banks in the state of Colorado. And so while there are larger banks across the country operating in all three of these states that have a fairly maybe sophisticated insolvency practice within them of some sort, and they're well prepared and they're well versed and they've done many receiverships, there are also a lot of small banks, as Brent mentioned, that maybe don't have that experience. And so I think it is an opportunity to continue to work with, to make sure that as a receivership approaches, it is putting them in the best place to make a strong decision and not make, either the wrong decision or not making a decision at all, which is ultimately ends up being probably the wrong decision. So, yeah.
And leads, Eric. We all want leads.
Yes. Yeah. Yeah. Bankers are going to be a hot commodity in person next year. I mean, they will be. You could be in Vegas throwing out free roulette chips, and people still go find the bankers.
Yeah. Well, I just, I say that flippantly, but I think credible sources of potential business is a huge value that an association brings its membership in any industry.
Yeah. Howard, how about you? What could CRA do for you?
I would say sort of consolidate into one spot or one group the knowledge of receiverships and the support that receivers offer in this state, because again, right now we have I would say most bankers are not aware of the remedy. Many lawyers have not heard of it or don't use it, and the judges are sort of all over the map on being in the dark as far as direction. So I would say just being a resource for any one of those three groups would be a huge step forward.
Yeah, I think being a resource for those groups. I think the theory amongst the insolvency community is that the tidal wave is coming. Now I've heard that for 2.5 years now, so this is a very slow moving tidal wave, but I think talking to receivers and attorneys in California and New York, they're getting really, really busy right now, that there's a ton of work coming. And so, our hope is that we're building that foundation right now in these three states, as well as we're rolling out in Minnesota on September 14th. We're rolling out in Oklahoma on October 18th. We have some plans in the works for DC, Virginia, Maryland, as well as Arizona this year, and a lot of future states next year. The idea that with a strong foundation, when that tidal wave hits and Brent is too busy to take on any more receiverships, and Ryan's too busy to take on any more receiverships, and Howard is, that you have the network to refer it and not feel like, I hope to God this works out, because I don't know this guy from other than what I was about to say what I found in the yellow pages, but I was told the other day those don't really exist. So what do I know? I mean, I think, how does that play out for you all? How does that structure, what does that structural support look like that would be of a strong benefit, not just to you, but your state communities?
Well, let me just start with this. And I have actually found it remarkably difficult to find the right attorney to represent me in a receivership who was either not conflicted through previous bank relationships or simply sometimes not qualified to do the work. So the very first thing that occurred to me at our first when I came to the first kickoff event was that suddenly I'm meeting attorneys who are specifically engaged in this work. And so the directory of services will be extremely important to everyone. And for those who practice receivers but are not part of a large national firm like mine with CPAs and lots of accountants and forensic investigators, and I mean, we literally have an expert for every field in my firm. So, but many people don't have access to that in-house. And so it's difficult to locate those specific experts, and the CRA can help with a directory for all sorts of resources that receivers need. I want to add one more point about this too. You know, it's also equally important to know when a receivership is not the right solution to a banking problem. And we have all seen this, where we're asked to do something or to do things that might have been better handled or could be better handled through a Chapter 11 or some ABC or some other process. So it's not just teaching people how to use it, but how not to use the codes.
For sure. Ryan?
Yeah, I don't have much to say about it. I would agree with that wholeheartedly.
I know you gave a good answer, Brent, when they just say, yeah, ditto.
Yeah.
So it's probably pretty good. And Howard, how about you?
I hate to say it, but ditto.
Well done, Brent. You know, so just a few more minutes here. We're going to actually get people out on time and not drag it on too long. But any kind of last parting thoughts of, you know, what you believe the CRA, you know, what you want to see out of it from yourselves?
Yeah, I think the momentum seems to be moving well. You guys are doing good work, Eric, to gather up. I think, you know, maybe for us state directors, a little bit more touch points in terms of helping that momentum on a more micro level in our individual states would be good for us, because I know, speaking for me, I'll get busy doing work and I'll forget all about this for a few weeks and then go, oh, geez, I got to focus on this a little bit, just like we do our board meetings and everything else, I'm sure. But, you know, just different ways for us to stay connected throughout each month probably would be helpful for me to stay engaged and just keep the momentum going. I think once you lose that momentum, it's just harder to get back on track. And especially out of the gate with you guys and the different states you're bringing on, I think it's a good time to just keep that going. And then, you know, maybe consistent messaging for us all when we're reaching out to new members, and we're advocating for the CRA for members that we want to bring on, judges, attorneys, bank clients, anybody else interested, you know, just so that we can all be saying the same thing in terms of what the benefits are, and not a canned speech, but just having best messaging.
Howard?
I'm looking forward to CLE next year with practitioners who either have done this for longer than I have or more extensively than I have, because I think you learn by other people's good experiences and bad experiences, and I think, you know, doing that in person is probably as good as the seminars have been. I think in person is going to be a much better experience.
And I think that's a really great point. Next year, 2023, St. Louis, August 21st through 23rd. I mean, I know personally, I listen to you three, I listen to Eric Peterson, Sinette Magnus, and the other people that we get to deal with on a regular basis. And I love hearing from you all. And partially, I always want to hear the horror stories, because those are the fun ones that I can go home and tell my wife. But, you know, I love learning from all of you. I mean, you guys all have such a depth of experience that really has made us be able to gain that traction and momentum in your states, as well as where we want to go with it. And so, you know, I think the ability to really showcase that depth of experience across the country, so that others can learn from it, because we all get into our rhythms and we don't necessarily always keep learning where we could apply something differently. And so I think it's a really, really great point of that learning in person next year. So thank you so much, all three of you, Brent King, Marc Spector, Ryan Gulick, for joining us today. This has really been a great closure to our conference today. I said it at the beginning, I'll say it now. Our goal was 50 people at this conference today, and we ended up with 55 registered. So anytime I beat my goals by 10%, I'm usually fairly happy with it, because I'm not someone who really likes to set low goals. So we really felt like if we got to 50, this would be a good day, and getting to 55 really just blew it away. Special thank you to our sponsors today, Spencer Fain, Carmody McDonald, Nimble Strategies, and Thompson Coburn. You guys have all really helped make this possible. We hope you all enjoyed the Whoba app. You will still have access to the Whoba app. We'll be continuing to upload the videos from these presentations today, so that if you want to go back and watch something, if you want to go back and see something, we'll get that out to you as quickly as we can, so that you can access all of that. For those that went through the process for seeking CLE as a part of the 3 sessions today, we'll be getting those certificates out as quickly as we possibly can. Mind you, we're a few volunteers working through this with full-time jobs that some days seem a lot busier than others. So we will do our best, and they will be out shortly, we promise. So in addition, members have access to the member resource library. It was touched on earlier, I think, by Brent or Ryan. By logging into the secure portion of the commercialreceiver.org, you actually have access to not just today's panels, but also the previous panels that we've accessed and done, as well as case studies, white papers, and more. So thank you everyone for joining us today. We've been thrilled with the response, the outreach. We were having a discussion in between these last 2 meetings. The amount of people that have gone onto the webpage and looked at our sponsors and clicked through to our sponsors' web pages blew us away, which we have to take as a good sign that people really want to know more about the receivership industry and who's practicing in it. And we appreciate that those people were really going through and checking everything out. So thank you today. This has really been a fascinating and fun day. And thank you 3 for all that you're doing for us. So really excited to see you 3 in the future at future events. We probably all should be talking about what's coming next in each of your states. So Ryan, that was a good reminder from you. Thank you. Have a great day.
Thanks, everybody.